And we are recording. You may have just gotten a message pop up on your screen that notified you that we're recording. So you might just want to put got it. Click on got it. Okay, everyone. Good afternoon and welcome to AAUW January meeting. This is actually our kickoff for the year of 2022. Happy New Year, everyone. AAUW is the American Association of University Women. Thank you, Kathy. If you'll just continue to let them in, then I'll do the welcome. And we're just want to say that we're glad that you were all able to join us. And we have all the members of AAUW. It's very nice to see your face. And for all of our guests, we want to say a special thank you for taking your time to join us this evening. And Attorney Julian Butler, we especially thank you and welcome you for being here with us. Just a little bit about AAUW. AAUW was founded in 1881 in Boston, and the Huntsville branch here in Huntsville, Alabama, was chartered in 1949. And just a little bit about our mission. At AAUW, we have led the fight for fair pay and economic opportunity for women, and the battle continues. Women still just earn 83 cents for every dollar paid to a man, and men continue to dominate the top roles and the highest paying professions. Although here at AAUW, we are nonpartisan, we are not values neutral, though. We fight to remove the barriers and biases that stand in the way of gender equity. We train women to negotiate for pay and benefits and to pursue leadership roles. And we also advocate for federal, state, and local laws and policies to ensure equity and end discrimination. Our focus is here at AAUW is economic security, education, and advocacy. I think at this time, if Cindy, did you have a little housekeeping that you might want to do at this time?
Yes, I'd like to ask everyone to please keep yourselves on mute. If you make noise, I have to come hunt you down and put you back again. So make it easy on all of us. But if you have questions to ask, we ask that you put the questions into the chat. Kathy Jones has offered to help with consolidating the questions, but also getting the questions out and helping to move them along that way. If we don't have too many questions, we'll open it up and let you ask them directly. But we wanted to have maximize our time with Julian today. So that's pretty much all the housekeeping that I have. Thanks, LaJoy.
Might want to unmute myself. And thank you, Cindy. Just want to remind everyone that we are recording the program tonight, and we do have a website for AAUW Huntsville. I am going to type it into the chat box so that anyone, you may want to join us or look and see what AAUW is about and what we represent and what our values are. You can definitely visit our website and learn all of that. At this time, Ms. Barbara is going to talk about our program tonight.
Well, I'm going to speak about what prompted me to ask Julian Butler in the first place. It really started back when we were having the federal Supreme Court nominee whole rigmarole. And I talked with friends and family, and so many of us didn't know any more about our local, we knew less about actually our local systems. And so then that's when I decided, I was asking questions of some people, the League of Women Voters and others, who would be a good speaker for us so that we could all learn about how Alabama worked and how the Alabama court system or any state court system fed into the federal court system. And so it didn't take me long to find Julian's name and recommendations. So we're excited to hear you, Julian, and see if we can all get better informed. So take it away.
Thank you.
Okay.
Julie.
Yeah, Cindy will do the introduction. And I just have a quick question here, and I just wanted to let them know. It says, will you be sending the recording to us? The recording will be on a YouTube channel, and we can put that into the chat also, so that you'll have that. Cindy's going to introduce our speaker.
Okay. I first met Julian when he chaired my leadership class in 1990. He's since spoken to many leadership classes on leadership, and many here tonight are alums of those talks. Julian is a shareholder in Dentons Sirote's of Huntsville, Alabama office. He represents clients in civil litigation matters. One of his focus areas is government law, and he served as the Madison County Attorney for 35 years. Julian was recently an inductee to the prestigious Alabama Academy of Honor, which bestows honor and recognition upon Alabamians for accomplishments and service befitting or reflecting great credit on the state. Some of his classmates and/or previous inductees: Secretary of Defense Lloyd Austin, Judge John England from Tuscaloosa, Lionel Richie. There also have been inducted into there is Senators Lister Hill, John Sparkman, Dr. Werner von Braun, Paul Bryant, and several former Alabama governors. In 2018, Alpha Phi Alpha Fraternity named him the Martin Luther King Jr. gave him the Unity Award for outstanding service in the area of human relations. And he's been awarded by the Huntsville-Madison County Bar Association with their Community Service Award twice. He has been an extremely prolific volunteer in his lifetime. He believes that lawyers ought to give back, and he served on many, many different boards and foundations and that sort of thing. And I'll tell you what, I'll put a bunch of those into the chat so that if anybody would like to see more, you'll be able to. But Julian, I am thrilled that you're here to talk with us tonight. And thank you. We'll let you start now.
Thank you, Cindy.
Sure.
Let me start off by saying I tend to express my opinions, and when I do, I want you to know my opinions are not the opinions of the AAUW or of my law firm. They're not even necessarily the opinions of my wife. They're mine and mine alone, and I take responsibility for them. Secondly, as I discuss the various courts, there are exceptions to almost everything I'm going to say. And you may hear something at some time. I have tried to get the basics on all of these courts. If I dealt with the exceptions, you would still be here this time tomorrow. I want to say this. One of the most progressive things Alabama ever did, in 1973, it passed Amendment 328 to the Alabama Constitution, which was named as a judicial article. Later, Senator Howell Heflin, who was then the Chief Justice of the Alabama Supreme Court, was the moving force behind it. And it created for the state of Alabama a unified court system from top to bottom. And it is a model for the rest of the country in regard to a unified court system. Yes, there's some inconsistencies and all of that, but it is the most progressive thing in the Alabama Constitution. When you start with courts, you start at a local level with municipal courts. And these are your city courts. And the judges for those courts are appointed by the municipal governing body. They must be lawyers. Most of the judges in the smaller municipalities are part-time. There are local lawyers that like to do it and may be the judge for multiple municipalities. The city of Huntsville has 3 municipal judges who are full-time. The jurisdiction of the municipal courts are limited to cases arising under city ordinances. They're criminal cases, they're misdemeanor cases. Many cities have adopted as part of their city ordinances the state law misdemeanors. So you can be arrested by a city policeman charged with what is a misdemeanor under state law, but has been adopted by the city. The judges must be licensed to practice law in Alabama. A municipality prior to 1977 could opt out and choose not to have a municipal court. Since 77, they're unable to do that. They must have a municipal court. And I think every municipality in Madison County has a municipal court. There are no juries, they're judges, and because there are no juries, you have a right, if you are convicted in municipal court, to appeal to circuit court and get a trial by jury. That's on the local level. They handle no civil cases. All they do are violation of city ordinances. And then you move on to the state. And you have the probate courts. And the probate court is unique in many different ways. One is that it has both executive and judicial functions. It is unique in that the judge, the probate judge, does not have to be licensed to practice law. I've practiced law in Huntsville for over 50 years. We have had some outstanding probate judges. We have never had a probate judge who was licensed to practice law. Usually they call upon the county attorney if there are complicated legal issues to assist them with them. There is one probate court in every county. The judges are elected in partisan elections. And when I use the term partisan elections, they run as Democrats or Republicans or whatever. They serve 6-year terms.
Got trees, water? We have water?
Yeah.
Trees?
They have, in their judicial roles, they handle adoptions, they handle estates, they handle condemnation cases, they handle guardianships, and probably one of the most difficult, they are the judge before whom people appear that are the subject of a commitment for being mentally ill, a commitment to a state institution. Settlement of estates can be appealed from the probate court to the circuit court. There are no juries in probate court. The administrative functions or executive functions of the probate judge, the biggest one is that's where you file deeds and mortgages and all of those type documents. You then move to what I call the real court system, and that is your district court, circuit courts, and then you go to the courts of appeal and the state Supreme Court. District courts, and there is one district court in each county. In Madison County, there are 4 district judges. You're mentioning your advocacy of the role of women. 2 of our district judges are female and 2 are male. The judges must be licensed to practice law in Alabama. The district court judges are elected again in partisan elections. They run as Democrats or Republicans. They have 6-year terms. They have both criminal and civil responsibilities. Their criminal responsibilities, they hold preliminary hearings in felony cases. That's the first time a person who is accused of a felony, well, they appear before them and to determine if they have a lawyer, and then they can demand a preliminary hearing. And if that, the judge does not find guilt or innocence, the judge merely determines if there is probable cause to believe the person has committed the offense and sends the case to a grand jury. They try misdemeanors. If you're arrested by a deputy sheriff, that's where the case would go to district court. As I said, there are no juries. You may appeal from district court again to the Supreme Court, to the circuit court, and demand a trial by jury. Much of what the district courts actually try are traffic cases. You have juvenile proceedings, and that varies from judicial circuit to judicial circuit or county to county. But that is where if a juvenile is picked up and charged, they are then tried by the district court judge. They try civil cases, again without a jury, where the amount in controversy is less than $20,000. And it is also small claims court is a part of the district court. And small claims court is our version of the people's court or Judge Judy or whatever. Most often, people that appear in small claims court represent themselves. It is a place where a corporation or a partnership can appear by one of their officers or partners without having a lawyer. Again, the parties may appeal the decisions to the circuit court and demand a jury. The small claims court exclusively handles cases where the amount in controversy is less than $6,000. If you have a lawsuit and what's being claimed is less than $6,000, that has to be in small claims court. And when I use the term amount in controversy, that does not mean what the case is ultimately worth. That means what the person filing the case, the plaintiff, claims that they're entitled to. In district court and in circuit court, vacancies are filled by appointment of the governor. And this is something that becomes very, very important. You have many situations where vacancies occur in the district court or in the circuit court. Judges die, judges retire, judges move on to something else. Among district judges, many of them have the ambition to be a circuit judge and ultimately move up to circuit judge. It varies from county to county, the exact method by which those vacancies are filled, although they're all ultimately filled by appointment of the governor. Madison County has a judicial commission. That commission has 9 members. 2 are lawyers selected by the bar, 1 circuit judge selected by the circuit judges, 2 citizens appointed by members of the House of Representatives from Madison County, 2 citizens appointed by the senators from Madison County, and 2 citizens appointed jointly by members of the House and Senate. The Judicial Commission takes applications when there is a vacancy of people wanting to be appointed a judge. They then conduct public interviews and vote publicly. And they send 3 names to the governor. The governor must appoint from those 3 names. If the governor makes no appointment within 30 days, then it goes to the Chief Justice of the Alabama Supreme Court to make the appointment. And as I said, this is very important. A significant number of the judges now serving and that have served in Madison County were appointed through this process. It sought to minimize the political involvement in the appointment of judges. The original Judicial Commission had 1 judge, 2 lawyers selected by the bar, and 2 citizens chosen by the legislative delegation. There was disappointment on the part of some legislators that somebody or some people were not chosen to go forward to the governor, and the legislature increased from 5 to 9 in the breakdown I gave you. That was in the form of a constitutional amendment, which was approved by the voters in Madison County. It gives the legislators basically 6 of the 9 votes and increases the influence of the legislature on the appointment of judges. The circuit court is really the court of general jurisdiction. This is on a state level, really the big boy as far as the number of actions. The circuit court has civil cases, criminal cases, and domestic relations or divorce cases. A circuit court may be for more than 1 county. The state is divided into 41 judicial circuits. As you know, there's 67 counties. So you have some multi-county circuit courts. Madison County is a single county circuit court, as are Morgan, Limestone, most of our surrounding counties. We have 1 circuit court in South Alabama that is composed of 5 counties: Bibb, Dallas, Hale, Perry, and Wilcox. There are a number of circuit courts that are 2-county circuit courts. The number of judges are set by the state legislature, as are the number of judges in district court. We have 7 circuit judges in Madison County. 4 are female, 3 are male. I think I'm correct that the caseload for judges in Madison County is the highest in the state of Alabama. And there have been repeatedly efforts to get the legislature to create additional judgeships. But again, the judges are state officials. They're paid by the state of Alabama. And so it becomes a financial question to the legislature. We have been very fortunate. We have 2 retired circuit judges that get no extra compensation for doing it. But Judge Bill Page and Judge Jim Smith volunteer to handle cases and lessen the load on the sitting circuit judges. They have contributed invaluably to the administration of justice in Madison County by their willingness to continue to serve. And as I say, they do so without any additional remuneration other than the retirement they're getting. The judges, again, as with district judges, must be licensed to practice law. They're elected in a partisan election and serve 6-year terms. There are jury trials. In a civil case, either party may demand a jury trial. And when I say demand, that's the technical term for it. But if one or the other does not demand it, then the case is tried non-jury. I would say the great majority of civil cases, the party filing the civil case, the plaintiff, includes on the complaint a demand for a jury trial. Circuit courts have the authority to review decisions of state administrative agencies, but because most of those agencies are located in Montgomery, that is primarily the Circuit Court of Montgomery County. Both the district court and the circuit court are considered courts of record in that there are court reporters who take down all of the proceedings. The court reporters are employees, but you see them sitting there with their machines taking everything down. They do not type up the transcript, that is the verbatim of the trial, unless one of the lawyers involved requests they do so, and that lawyer has to pay for it.
Julian, I want to interrupt just real quickly. A lot of folks came on after we did housekeeping, and just ask everyone, if you have questions, please put them into the chat. We're going to come back to questions when Julian's gone through his overview. Thank you.
Decisions of the circuit court are appealed to the courts of appeal. In Alabama, we have a court of civil appeals and a court of criminal appeals. For many years, Alabama had a single court of appeals that handled both civil and criminal. A number of years ago, they were split, and you have the court of civil appeals and the court of criminal appeals. The judges must be licensed to practice law. They're again elected in partisan elections for a 6-year term. All of the judges in the state system that run for election, and that's probate judge, the district judge, the circuit judges, and the Court of Appeals judges and the state Supreme Court judges, all serve 6 terms. The Court of Appeals handle the cases that are appealed for the circuit courts. The decisions may be appealed to the Supreme Court of Alabama, and that in civil cases is permissive. You have a right to say, I want an appeal to the Alabama Supreme Court, but you file what we call a writ of certiorari. It's a Latin term. You are asking the state Supreme Court to hear an appeal from the circuit, from the courts of appeal. The Supreme Court does not have to do so, except in some cases. In a death penalty case, the Alabama Supreme Court must hear them. It's interesting, and I started to say only in Alabama, but that's not true. You have a lot of unique things. There is a presiding judge. There are 5 judges on each of the 2 courts. That one of them is the presiding judge. And that does not give that judge any more authority, really, but gives it administrative duties. And I get them confused. But for one of the courts of appeal, the judges elect the presiding judge. And in the other court of appeals, the senior, the judge that served the longest, is the presiding judge. Don't ask me to explain why there is a difference. One thing in dealing with appellate courts, and we're talking about the Court of Civil Appeals, the Court of Criminal Appeals, and the state Supreme Court. And the same will be true when we get in the federal system and are dealing with the circuit courts of appeal in the federal system and the U.S. Supreme Court. They do not try cases. They do not have juries, and they do not hear live witnesses. The facts as presented in the court below or what is presented to the Court of Appeals. And their obligation is to determine questions of law. Were there mistakes made in the court below, mainly the circuit courts, that would cause the appellate court to reverse? And that could be a judge's ruling on pretrial motions, a judge's ruling on the admission of evidence in the trial. If you've seen trials, you will have Your Honor, I object to that question, or I object to that being admitted to evidence, and the judge must rule on that, and that or can form the basis of an appeal that the judge ruled incorrectly. The judge in a jury case charges the jury as to what the law is, and again, the lawyers can accept to the charge, and that gives them a basis for appealing that the judge misstated the law. I think of all the things in regarding cases or courts in Alabama, that may be one of the most misunderstood. People think, well, I lost in circuit court, I'll just appeal and get a different, try it over again. That isn't the way it works. If you try a case in circuit court and lose, you can move for a new trial in the circuit court. And the judge who tried the case, if they think they made a mistake, and if the lawyer points out to them they made a mistake, can order a new trial. And that is in civil cases or in criminal cases. But when you go to the appellate courts, what goes forward really are all the pleadings in the case, the transcript of the trial, and that's the verbatim transcript. And then the lawyers file their briefs where they point out what they think the mistakes are and why the case should be reversed. Both sides file briefs. There can be oral argument. You must request oral argument, and the court has a right to grant or deny. Most lawyers like me have never been sure what tweaks the court when they grant oral argument or when they don't. Less and less does the Supreme Court of Alabama grant oral argument. You then go to the Supreme Court of Alabama. Again, there are 9 judges of the state Supreme Court. They must be licensed to practice law. They're elected for 6-year terms in partisan elections. They run as Democrats, Republicans, whatever. Normally what the Supreme Court does, if they're having oral argument, they sit in 5-judge panels. That is the presiding judge and 4 other judges hear the case. If a lawyer loses before the panel, he can request that the entire court hear it, which is called en banc. The court may or may not grant that. As I say, there are no trials in the Supreme Court. They handle the appeals the same way they do in the courts of appeals, based on the pleadings, the transcript, or what we call the record, and the briefs, and if there's oral argument, the oral argument of the lawyers. The Supreme Court can render advisory opinions on constitutional questions. At times, the governor, either house of the state legislature, may request the Supreme Court to enter an advisory opinion. You find that most often when the legislature is considering legislation that may be controversial as to its constitutionality under the Alabama Constitution, they may request an advisory opinion of the Supreme Court. The Supreme Court does not have to grant them, and their advisory opinions are not do not set a precedent. The way if the Supreme Court rules in a case, that's the law of the state of Alabama, and that should be followed in all circuit courts and district courts and probate courts. With advisory opinions, they are persuasive to lower courts, but not necessarily binding on them. Unlike the courts of appeal that select, as I said earlier, the presiding judge. The presiding judge or the Chief Justice of the Alabama Supreme Court is elected as Chief Justice. He or she runs in a partisan election, but they run for the specific office of Chief Justice. And the Chief Justice is really the chief executive officer of the Alabama court system. He or she have not only ministerial responsibilities in regard to the court, but other responsibilities in regard to the administration of the court system. There is an organization called, a state agency called the Administrative Office of Courts that really administers the court system in Alabama under the leadership and direction of the Chief Justice. That pretty well covers the state court system in Alabama. You then move to the federal courts that sit in Alabama. You have the basic federal court in Alabama are the district courts, and that's why it's sometimes confusing. You have district courts in state, and you have federal district courts. The judges of the federal district courts are appointed by the president, must be confirmed by the United States Senate, and they're appointed, quote, upon good behavior for life. They can be removed by impeachment before the U.S. Senate, as a president would be removed by impeachment. You're impeached by the House and you're convicted or tried, and it's convicted by the Senate. The state of Alabama is divided into 3 districts: the Northern District, the Middle District, and the Southern District. We are in the Northern District. It is much the largest of the 3 districts. If you drew a line right south of Tuscaloosa and drew it across the state of Alabama, everything north of there would be in the Northern District, much more heavily populated than the other 2 districts. The number of judges for each district is set by Congress. At the present time, there are 7 district judges for the Northern District. A judge reaching a certain age and a certain amount of time as a district judge can take what we call senior status. That does not count then as part of the 7. Those judges continue to serve within certain limitations that they set themselves. We have a number now serving in the Northern District. We have a full-time federal judge, district judge in the for the Northern District sitting in Huntsville, and that means he has his chambers here. That's Judge Lyles Burke. Judge Linwood Smith, who was his predecessor, took senior status. He still maintains his office here, and he still carries a nearly full-time load. It would be very burdensome on the 7 judges if the senior judges did not continue to take cases. As I said, they're lifetime appointees. They're paid for life. And if you continue to work in your senior status, you don't get paid any more money. You are not required to do so. The district judges try both criminal and civil cases. They have jurisdiction of cases arising under the Constitution and laws of the United States, cases in which the United States is a party, cases between citizens of different states. And that's what's known as diversity jurisdiction. And that means if I am a citizen of Tennessee and I have a case against a citizen of Alabama, I can bring that case in the United States District Court in Alabama if the amount in controversy, and again we go to that term, if the amount claimed is in excess of $75,000. You have all crimes under federal law are tried by the district courts, with an exception I'll get to when we get to the magistrate judges. You have in the district court, there are juries. Cases are tried both with, and again, juries can be waived, the same as in the state circuit court. You have in federal court, and the ones that attract the most attention really are usually civil rights cases, cases where people are alleging a violation of constitutional rights. And that is something that is really, I was a federal judge's law clerk in 1965. That was not true in 1965. Many of the cases we had were diversity cases where there was a large trucking accident or a contract dispute between a citizen of Tennessee or Georgia or New York or whatever and a citizen of the state of Alabama. But now an awfully lot of them are civil rights cases or based on employees that allege that their civil rights were violated when they were terminated. And this is particularly true, or usually true, when they are government employees, or employees of a city government, a county government, a state government. The district courts are very similar to the state circuit courts in that they're where the main action is. And as I said, they are both jury and non-jury. Cases decided by district courts are appealed to the circuit courts of appeal. There are 11 circuit courts of appeal. We are in the 11th circuit, which is composed of Florida, Georgia, and Alabama. It's headquartered in Atlanta, although it sits in Tallahassee and in Montgomery. That is the whole court. The judges are appointed by the president, like district judges. They're appointed for life, and they must be confirmed by the Senate. There are 12 judges of the 11th Circuit Court of Appeals. And again, you've got senior judges that continue to serve. And when the 11th Circuit sits, and when I say sits, when they have oral argument in cases, It sits in panels of 3 judges. And very often they will designate a district court judge to sit with 2 circuit court judges to make up the 3-judge panel of a circuit court of appeals. They do it because of manpower, and they also do it, I've been told, because it is very helpful to district judges to see how the circuit courts of appeal operate, and that will help them in their duties. Again, like the panels of the Alabama Supreme Court, if a lawyer tries a case before a 3-judge panel of the 11th Circuit Court of Appeals and is disappointed in the outcome, the lawyer may request an en banc hearing. It's a term we use. It means to be heard by the entire court, the entire courts. Again, as with the appellate courts in Alabama, they do not try cases. They again receive copies of the pleadings, the transcript of the trial, and the briefs of the lawyers. And if there is oral argument, they take all of that into consideration. And they're trying questions of law. They are not retrying questions of fact. You then can appeal cases to the United States Supreme Court. Again, like the other federal courts, the justices are appointed by the president for life, confirmed by the Senate. There are 9 justices of the United States Supreme Court. The Chief Justice is designated by the President of the United States. The Supreme Court hears appeals for circuit courts of appeals, and in certain cases, you can appeal a decision of a state Supreme Court. That's the highest court in the state, to the United States Supreme Court. They have what we call original jurisdiction. You can file a case there that has not been up through the federal system, and those are actions between states. And in some cases where a state is a party, they have original jurisdiction where a foreign country is a party. And there are a lot of other situations where the Supreme Court may have original jurisdiction. You then have 2 kind of specialty federal courts. You have magistrate judges, used to be called just federal magistrates. They're now called magistrate judges. They are appointed by the district court for a term of 8 years. They may be reappointed. They try federal misdemeanors. The federal magistrate tries traffic cases for off the arsenal or off TVA lines, TVA property. They hear pretrial matters in both civil and criminal cases. With the consent of the parties, they may conduct all proceedings in a civil jury or non-jury case, including a trial by jury. When a case is filed in the Northern District, the lawyers receive a form as to whether they will consent to it being tried by a magistrate judge. And if they do, then that would be the trial of the case. If they try a case, the appeal would then go to the Circuit Court of Appeals as if a district judge had tried. You then have the bankruptcy courts. Bankruptcy is a federal matter. You have bankruptcy courts, again, in each judicial district. The judges are appointed. They're for the judicial district, but they're appointed by the Circuit Court of Appeals for a 14-year term. There are 5 bankruptcy judges in the Northern District. They may have jury trials, and that gets into some very technical stuff. That's not very often. They are mostly, the judge handles them. They handle all bankruptcy proceedings. And if you file a bankruptcy and there's a ruling of the bankruptcy court with which you disagree, you can appeal to the district court. There are other federal courts not located in Alabama, Court of Claims and those kind of things, that I have not dealt with. They are very specific types of cases, and you normally don't hear a lot about them. One thing I did not mention in the admiralty courts, in the district judges, federal district judges, they also hear admiralty cases. And admiralty cases are cases arising on something that occurred on a navigable waterway of the United States. Most admiralty cases are in places like New Orleans, where you're dealing with the Gulf of Mexico or the Mississippi River. But the U.S. District Court for the Northern District of Alabama would hear an admiralty case arising from the Tennessee River. And that is if 2 boats have a wreck on the Tennessee River, or if a barge destroys something or whatever. That's a navigable waterway of the United States. And you would have that case brought in federal district court. I hope I have given you an overview of the courts that exist in Alabama, both state and federal. And Cindy, or whoever's going to conduct it, I will now attempt to answer questions.
Thank you, Julian. That was, I've never known a lot of those facts and thought I knew a lot about the court system. LaJoy or Kathy, do y'all want to ask questions?
I can go through the questions if you want me to.
I can start. We have some questions that were posted in our chat, and I will just start at the top. We have a question. Well, actually, this one was from myself, because while you were talking, I got a phone call and somebody said, where in Huntsville, Madison County, is child support court held?
That is a domestic relations, and it is handled in the circuit court.
Circuit court. Okay, and that was pretty cool, because I told her, I said, isn't that something? I'm on the Zoom with an attorney right now. I will ask your question and get back to you when we're done. So thank you for that answer, and all I have to do is look up circuit court, and she will know exactly where to go.
I've got everything.
All right, here we go. Okay, Kathy, what was, Julian had asked the question, answered the question about the family court.
Yeah, hold on. We'll get rid of that. Hold on one moment, and I will read you the next question. Is he online? I can't see while I'm looking at the.
Yeah, Julian.
Yes, I'm online.
Can y'all hear him?
Okay. Yes. Okay.
Good.
The next question came from Barbara Cadell. What, in your opinion, is the best way to select judges in the state court system?
Not through partisan elections. There are a number of ways, and Alabama made a real drive for it in the 70s, I guess. In some states you have where you have a commission selects the judges, and then every 5 or 6 years, whatever, their name goes on the ballot with the question, should Judge Jones be retained in office? To me, that is preferable to a judge having to run, first of all, in a party primary and then in a general election. I know they're good men and women who would make good judges, just don't want to be a part of the political process.
And Julian, you couldn't see the visual, but everybody whose screen is live when you said that shouldn't be a partisan election nodded their heads in agreement. Just for some feedback there.
Okay.
Okay.
All right. So the next question is from Jen Threet. What happens if your lawyer doesn't provide effective counsel?
Okay, in a civil case, in a civil case, you can sue the lawyer. In a criminal case, that is the basis for an appeal, that you were denied effective counsel. Sadly, that happens in a lot of criminal cases when the person is convicted and they're angry about it, and very good lawyers that have done a very good job will be caught in an appeal where the person who's been convicted claims that they received inadequate counsel.
Thank you, Julian. Next question. I'm just going to go on down the list, Cindy, if that's okay.
That's good.
Okay. The next question was, at what court level can a person request a reduced or lesser sentence, including fines and fees? And we're talking the state level.
That, I'm not sure. Basically, that would be, they would go to the court that convicted them and ask for a reduction. On an appeal, that's hard to do unless you claim that the fine or whatever exceeds the law. But if it is within the law, it would be really discretionary with the judge that imposed the fee or fine.
Okay. All right. Thank you. The next question, is there a database similar to Alicourt at the federal level?
Yes.
Okay.
I can't tell you how to get it, but I think you have to pay for it. We have it here at the law firm, of course, as do most law firms. I just don't handle the technicalities of it and can't answer that question. But yes, there is.
Okay. All right. The next question came from Carlos Finley. You referred to some judicial circuits that consist of multiple counties. Please touch on why Jefferson County has two separate circuits, Birmingham and Bessemer. Judges run for election countywide, but have jurisdiction limited only over certain portions of that county.
I wish I could answer that. I don't know. I've never understood it, and I don't think it's a good thing. We have had, though, that is not necessarily unique. Well, the running, you either run from the cutoff, the Bessemer cutoff, or from Jefferson County. That is unique. We have had other counties, and Marshall County is one of them, where there are two courthouses, one in Albertville and one in Guntersville. And I think they changed it now, but a long time, when you filed a civil lawsuit in Marshall County, you had to file it in the courthouse, and the county was divided as to whether this is an Albertville case or a Guntersville case. There is a historic reason for that. If you can picture going up the mountain from Gunnersville to Albertville, way back in the winter, you couldn't get up the mountain, so you had two courthouses. Similar situations were in Winston County, in St. Clair County, and both of those were like Gunnersville. They were natural, there were mountains you had to get over or whatever. Most of those have now been abolished. The Jefferson County situation is unique, and I've never heard an explanation for it.
Thank you. Kathy, you're muted.
Sorry, I was going to the next one, and Janice Marsh asked, what year did the legislature increase the number of individuals on a judicial commission from 5 to 9?
I don't have that in front of me. There's nothing I can grab in a hurry that will tell me that. I do not, off the top of my head, I do not know.
Okay.
It has been a while ago, probably in the 1990s would be my guesstimate.
All right. There was a question that I had not fully captured when the line went down, and that was from Barbara Cadell talking about the funding process. If we want to go back to that, or you may have some more questions, Cindy, that are online right now. I see 2 comments.
Barbara, if you want to ask your question, go right ahead. That second question.
Well, my question was to see what there's always a controversy in Mobile about who pays for what part of the judicial system in state court. And the district attorney and the county commission and the office of courts are always going around and around. And how is the state court system funded?
Well, it is basically and should be funded solely by the state of Alabama. That has not always happened, and Madison County District Attorney's Office is a very good example. The state funding for the DA's office here was woefully inadequate, and the county commission for, 50 plus years or whatever, have supplemented the pay of supplemented the appropriation to the district attorney's office. That conflict is very common, and where the division comes, the county is responsible for providing the courthouse and the offices, and there's can be controversy about how many courtrooms and what shape they're in, and the judge's offices, those type of things. You formerly had, in many, many counties, a county supplement to the state judge's pay. And finally, 25 years ago, whatever, the state did away with that, and you no longer have counties that paid a county supplement to circuit judges. And that was not uniform across the state. You would have Madison County might supplement it by 25%, and the next county might not supplement it at all. It was matters of local legislation. But unfortunately, even with a unified court system, there still isn't a clear solution to that problem. And it does, like everything else in Alabama, comes down to we just don't have enough money, or don't choose to spend it in certain ways.
Or don't choose to raise it in certain ways.
Well, exactly.
I have a question from Linda Barron from Birmingham area. Is it true that the legislature is taking judicial seats from the major metropolitan areas and moving them to rural areas, even though the metros are so backed up with cases?
Okay. My top of the head answer is no. I would need to know specific situations. The legislature deals with caseloads, what the caseload of a judge is. Sometimes that, an important part is how many judges they are. I understand that there is a push to move maybe one or two of the slots in Jefferson County to Madison County that I do not consider a rural county. But all of that is based on caseload. And in Jefferson County, you have a very unique situation where you have a family court and they're judges of just the family court. You have a criminal courts and they're just judges of the criminal courts. And then you have the civil division. Sometimes that results in disparities in the caseload of judges. And that's where it all becomes a balancing act. And that's where in Madison County, where we have been for years pushing for creation of more judges because of the caseload of our judges. But yes, the legislature has the power to do that.
Linda, if you're still on, if that wasn't what you were asking.
Well, of course, I hear a different story in Jefferson County, and they say their caseload is huge there, but that they're taking the seats. I know that Huntsville maybe got one not that long ago, but they're wanting to move them to Republican areas from Democratic areas, the judicial posts, and that some of the rural areas, the judges only go to work 2 or 3 days a week, whereas they're, some of our judges have 5,000 cases on the docket.
And volunteer.
I have no idea. I mean, I'm just a regular person, not a judge or a lawyer.
Statistics, this is the first time I've heard that. I will say it wouldn't shock me, but, I just don't know. And sometimes it comes down to how powerful is the legislative delegation, a particular legislator from a given county, and what committees they're chairman of and all of that when you begin shifting the number of judges.
Thank you. There's a question on the original chat before we got cut off. And it was from me, and I had asked Julian, can you talk about advantages or disadvantages of the possibility of expanding the U.S. Supreme Court beyond the current 9 justices?
I am another traditionalist that I'm not sure I think it's a good idea. You get then, okay, are you going to sit in different panels? Like the Alabama Supreme Court does. I understand when the Supreme Court totally frustrated FDR's New Deal program, FDR proposed expanding the Supreme Court, and the purpose of it was to blunt the impact of the conservative justices. I think that's what's moving it now, people that are dissatisfied with the conservative majority on the Supreme Court. I don't think that's a good reason for enlarging the court. And that's all I've heard as a reason for enlarging the Supreme Court. I think if you had 5 or 6 justices that favored the position of the people who are proposing it, they would be aghast in enlarging the Supreme Court.
Thank you. John Williams is asking a question. I'm going to try to articulate this, John. In a federal election, if state election officials decide to ignore the will of the voters in terms of overturning an election, would that then go to state courts, federal courts, or progress through both?
It's according to where, first of all, you get to whatever the claim is. Mm-hmm. And when you say ignore the will of the voters, you've got to have something that happened, you got to claim that votes weren't counted or illegal votes were counted or whatever. Normally those would start in state court, but in a federal election, they would probably go to federal court. during the last election, I don't know, there were 90 some odd cases or whatever filed all over the country, and none of them in Democratic states, Republican states, with Democratic judges, Republican judges, judges appointed by Democrats and Republicans, was there ever any finding of any kind of massive fraud or disregarding the will of the voters. But yes, according to what the basis of the claim is, it could be filed in either state court or federal court, but it must allege a violation of state law, the federal constitution. It just can't be. I believe that fella just didn't count it right.
Okay, I believe that that's our last question. Julian, thank you ever so much. I believe Barbara we have a gift for you, and we'll get it to you. And I believe Barbara may have it so that she can show it to you. It's our AAUW branded mug.
Oh, wow.
Yeah, it's a nice one, actually. So we'll get it to you.
Cindy, thank you. Thank you. I hope I haven't offended anybody.
No.
And I hope I have provided some useful information.
You did very much so, in my opinion. LaJoy, do you want to take us out?
Yes, I just want to say thank you. Thank you to all of our guests, all of the AAUW members and non-members that have joined us. And you definitely provided good information, practical information for me, so we can pay it forward. So I will let my friend know that information for the circuit court. And we did answer all of the questions that everyone had. It was a pleasure meeting you and hearing your bio also.
Thank you. Thank y'all. Good luck to you. Keep up your good work.